What is predatory pricing and is it illegal? Have you ever wondered how some companies can sell their products at prices that seem too good to be true? This practice is known as predatory pricing, and it raises important questions about competition in the market. So, what exactly is predatory pricing, and is it against the law? Predatory pricing occurs when a company sets the price of its goods or services extremely low, often below the cost of production. The main goal of this strategy is to eliminate competitors from the market. By driving rivals out of business or discouraging new companies from entering, the firm aims to gain a dominant position or even a monopoly. In the context of law school, predatory pricing is a key topic under antitrust law. Antitrust laws are designed to promote fair competition and prevent monopolistic practices. To determine if a pricing strategy is predatory, three main elements are considered. First, the company must be pricing below cost. This means the prices are set lower than an appropriate measure of costs, such as average variable cost or marginal cost. This indicates that the pricing is not sustainable for profit and is instead aimed at harming competitors. Second, there must be an intent to eliminate competition. This means the pricing strategy is not just about competing aggressively, but is specifically aimed at driving competitors out of the market or preventing their entry. Third, there needs to be a likelihood of recoupment. After competitors exit the market, the firm must have a reasonable chance of raising prices above competitive levels to recover the losses incurred during the predatory pricing phase. Now, is predatory pricing illegal? Yes, it is illegal under United States antitrust laws, particularly Section 2 of the Sherman Act. This section prohibits monopolization and attempts to monopolize. However, proving predatory pricing in court can be quite challenging. One reason is that lower prices can often be a legitimate competitive strategy that benefits consumers. Courts requiring evidence that shows prices were below cost, that there was an intent to eliminate competition, and that the firm can later raise prices to recoup losses. Additionally, courts often look for strong economic evidence to distinguish predatory pricing from healthy competition. Predatory pricing cases focus on whether the conduct harms competition itself, not just individual competitors. While short-term consumer benefits from low prices can be appealing, they may mask long-term harm if a monopoly is established. Companies accused of predatory pricing might argue that their low prices reflected efficiency or normal competitive behavior. Antitrust enforcement agencies and courts use various economic tests, such as the Turner test, to assess whether prices are below an appropriate measure of cost. It is also worth noting that predatory pricing is relatively rare in practice. This is because it is costly and risky for the predator. The company incurs losses and must sustain them long enough to push competitors out and later raise prices profitably. In summary, predatory pricing is an anti-competitive practice involving below-cost pricing intended to eliminate competition. It is illegal under antitrust law, but proving it can be complex due to the challenges in distinguishing it from legitimate competitive pricing. Understanding these concepts is essential for anyone studying antitrust law in law school.